children's rights, human rights, and Clause 2 of the BELA Bill. Important points to consider. This presentation is the genuine opinion of the author, who is not a homeschooler, has zero party political affiliations, and whose special focus is on the rights of young people rather than the rights of their parents. It's informed by ongoing discussion and consultation with various young people throughout, as well as by 7 years of active engagement with public participation processes, including conversation with diverse other attendees at live events. It's also offered to you under a public domain license, which means that, subject only to your genuine intent to support the empowerment and safety of South Africa's young people, you are indeed free to share, publish, quote, create new works of any kind using this content, and even go ahead and earn from them if you can. You're welcome. And along with all of my other content, this is not legal advice. On the 20th of March 2024, the day before Human Rights Day, the DBE's response to written and oral submissions by the public and various organizations opened its presentation with an assertion that the Basic Education Laws Amendment, or BELA Bill, is intended to deal with impairment to access to education, lack of integration, religious and cultural intolerance, lack of human rights culture, ineffective SGBs, and non-compliance to the Constitution. I wish to address the fourth of these points. I do agree with the DBE that there is a problematic lack of human rights culture in their system. However, I don't believe that the BELA Bill does much to improve this, beyond Clause 7 insisting that codes of conduct in schools must allow for a variety of beliefs and cultures, which the documentation suggests basically boils down to allowing nose studs and for hair to be worn in dreadlocks, i.e. a cosmetic amendment in every sense of the word. Instead, I believe that Clause 2 of the BELA Bill enables a number of serious state abuses that can further erode fulfillment of the right to education, as well as potentially violating a number of other rights of learners, teachers, parents, and political opponents of any future ruling party. I contend that the BELA Bill significantly fails to respect, protect, fulfill, and promote human rights, including all children's rights, including the right to education, and that allowing it to be passed will signal to ruling parties and all state departments that this is normal and acceptable practice, which will facilitate South Africa's continued democratic backslide. I offer this contribution of this presentation for the best interests and empowerment of South Africa's young people today on the 21st of March 2024, Human Rights Day in South Africa, except that it took me the whole of that day to put this presentation together, so it's actually being recorded now the day after. I would love to hear your thoughts on this presentation once you've given it a read or a listen. I welcome all honest and thoughtful comments, whether you disagree or agree with what I have to say today. Now, my slides froze there for a moment, which gave me the opportunity to take a deep breath, because what I'm going to say now is, I have to say it, because that's how it is. So, let's lay the foundations. States assume obligations and duties under international law to respect, to protect, and to fulfill human rights. The obligation to respect means that states must refrain from interfering with or curtailing the enjoyment of human rights, and that is a quote from the United Nations Information Service. This means that the state must not unnecessarily impose on citizens in ways that interfere with the enjoyment of the citizens' rights. Obviously, sometimes they have to, but those impositions must be carefully considered and justified and strongly and clearly motivated. South Africa's constitution stipulates that the state must respect, protect, fulfill, and promote all rights for all citizens of all ages. What does this mean? So respect means that the duty to respect means that the states themselves must not violate or act to interfere with the individual's enjoyment of all of their rights. Protect means that the state must ensure that other people don't violate, infringe, or block anyone's access to any of their rights. Fulfill means that the state must take positive action to facilitate the better enjoyment of all rights by all people, and promote means that the state must use education and information systems to help everyone understand and understand the importance of respecting human rights in our society. It's all a little abstract, so let's get a little bit concrete. So how this applies to the right to education, for example. Respect means that the state itself must not violate or interfere with the child's enjoyment of their full right, and it's a right to a truly child-friendly optimal education, not just any education, and the state must not violate or interfere with any of the child's other rights in the name of education. Quote from the UNCRC General Comment 1, children do not lose their human rights by virtue of passing through the school gates. Protect means that the state must be sure that other people don't violate, infringe, or block the child's access to education or any of their other rights. And this is where we see laws criminalizing people who prevent the child from educating themselves. So, for example, where a parent refuses to allow a child to learn, one of the most obvious cases would be sexist parents who refuse educational opportunities to girl children or to disabled children, then the state must step in. That is part of their obligation to protect. Fulfill. States must take positive action to facilitate the better enjoyment of the right to education by ensuring that all children have access to quality child-friendly educational options, which is why states generally set up a public school system that is free, but also needs to be more than free. It also needs to actually embody all of these other criteria, such as being child-friendly and high quality and effective. The obligation to promote in the educational context is that the state should use education and information systems to help all ages understand the child's right to education and everything it involves, as well as all the other rights that children have, not only by teaching them about their rights, but by ensuring they have a lived experience of their rights. And this is something that many people do not realize. Let's have a look at the justification for me saying that in a few minutes. But before we go there, let's mention the preamble, because this is the big heads up for what's actually going on with the BELA Bill, and I think we need to look at it first before we carry on with more things that feel a bit abstract. This is very concrete. During submissions to the National Council of Provinces last week, the South African Public Interest Law Centre, Section 27, asked for an adjustment to the amendment being made to the preamble of the South African Schools Act. The existing SASA says that the public education system needs to uphold the rights of all learners, parents and educators. The memorandum explaining the BELA Bill claims that it is necessary to ensure that systems of learning and excellence in education are put in place in a manner which respects, protects, promotes and fulfills the right to basic education. So we see that full phrase of all four words coming in there. But this is only in the memorandum explaining the bill. By the time we come to the bill itself, that learning and excellence in education has been left behind, and as we've been repeatedly told more recently, the bill now is really a bill about management and governance rather than being a comprehensive education sector reform, which is what we hoped for when we originally saw phrases like learning and excellence in education a few years ago. And I believe this reveals what the DBE considers to be its core priorities. But now here's the humdinger. In keeping with this shift, the amendment to the preamble of BELA now has two of those four words conveniently erased from the commitment to uphold the right to education. See if you can spot which ones are gone. The BELA amends the SASA to commit to facilitate the education of children through the promotion and protection of the right to basic education. Okay? Yeah. The two words that disappeared were respect and fulfill. Why do they matter? Why am I making a fuss about this? Respect means that the DBE itself must not violate or act to interfere with the child's enjoyment of their full right to truly child-friendly optimal education. That word has been taken out. Protect means that the DBE must ensure that other people don't violate, infringe, or block the child's access to education. That word has been left in. Fulfill means that the DBE must take positive action to facilitate the better enjoyment of the right to education by ensuring that all children have access to quality, child-friendly educational options. That word has been taken out. Promote means that the DBE must use education and information systems to make sure everyone understands that there is a right to education. That word has been left in. In other words, we see a very subtle but clear message here that the DBE commits to making sure everyone knows that there is a right to education in order to justify the DBE getting involved when other people can be accused of impacting the child's right to education. What the DBE does not seem to commit to here is avoiding negatively impacting the right to education itself, and also does not commit to providing for the fulfillment of the right to education through its own services. During submissions to the NCOP, Section 27 pointed this out because it actually is problematic. They said that Clause 40 of the BELA should be rephrased to encompass the full extent of the obligations imposed on the state by Section 7.2 of the Constitution in relation to the right to basic education, and therefore recommended that the amendment must say, facilitate the education of children through respecting and protecting and promoting and fulfilling the right to basic education. All four must be there. In the DBE's response session on the 20th of March 2024, this recommendation was completely ignored and wasn't even mentioned in the DBE's summary. And you can click those links, I'll pop them in the description of the video, so you can actually go and have a look for yourself. While you're there, have a look, if you're up to it, compare all of the other presentations to what they actually said and what was summarized and responded to or not in the DBE's response session. It's really quite enlightening. Continued, this preamble. In addition to using all four words in the preamble, as well as in the embodied philosophy of the DBE, I also believe that it's necessary to add something else, that they need to respect, protect, fulfill, and promote all other rights to which children are entitled by South African legislation and the United Nations Convention on the Rights of the Child. Why? Far too often the right to education is treated by education departments around the world as if it is the only right that matters for children, and all other rights of children can justifiably and summarily be compromised in the name of education, which is not how these rights were intended at all. In fact, all rights matter, and the state and every organ of the state has an absolute obligation to respect, protect, fulfill, and promote the full range of children's rights, including, but not limited to, the right to education. Again, children do not lose their human rights by virtue of passing through the school gates. Under what circumstances can children and adults have their rights limited in ways that are acceptable? Because obviously there are situations where states have to limit rights. So, this has been dealt with in detail. The rights in the Bill of Rights may be limited only in terms of law of general application, to the extent that the limitation is reasonable and justifiable in an open and democratic society that's based on human dignity, equality, and freedom. And every time the state decides to limit a right, they have to take into account all of these factors. The nature of the right, how much difference does it make to your life whether you get to enjoy it? The importance of the purpose of the limitation. For example, if we're jailing a murderer so that they don't murder more people, that's quite an important purpose. We can start saying we could justify limiting his right to liberty. The nature and extent of the limitation. How long are we going to jail him for? How long are we going to limit his right to liberty? Are we going to put him in solitary confinement, or are we going to give him house arrest? We have to consider this carefully according to what the purpose is. And what's the relation between the limitation and its purpose? And are there any less restrictive means to achieve that purpose that don't require us to actually interfere with somebody's fundamental rights? All of this is outlined in the Constitution of South Africa. So right here is the template that gives us the ability, when we come to creating law, to be able to do it in an ethical and human rights aligned way. In other words, before limiting the enjoyment of any right, the state must first consider how fundamental is this right, how does it affect the enjoyment of other rights, what are the potential impacts of limiting this right, how important is it that the purpose be achieved, what are the relative impacts of achieving or not achieving the purpose compared with the impact of limiting the right. Are there any less restrictive means we could use to achieve the same purpose? We need to be able to explain how limiting the right will reliably achieve the purpose. And we have to determine the extent of interference truly actually needed in order to achieve the purpose. So let's get that a little bit clearer. So only when the purpose is truly important enough to justify limiting the enjoyment of that particular right to that extent, and research shows that there's no less restrictive way to achieve the purpose, and there's solid evidence that the purpose will be achieved by limiting enjoyment of the right, then the state may limit a person's enjoyment of a particular right, but only up to and not beyond the extent necessary to achieve the purpose. Laying all of that foundation gives us a way to look at what's actually been done in the BELA Bill. So this is how it should have been done in the BELA Bill. This is the process they should have gone through. When they drafted Clause 2B, which increases the potential sentence for parents who do not succeed in getting their children to attend school, which reads, any parent who, without just cause and after a written notice from the head of department, fails to comply with subsection 1 is guilty of an offence and liable on conviction to a fine or imprisonment for a period not exceeding 12 months, or to both such a fine and imprisonment. The DBE was legally obligated to first, before proposing any amendment such as this, they needed to first consider that the parent's right to liberty is fundamental and that limiting this right impacts the enjoyment of almost all other rights. There's not very much you can do with your other rights when you're in prison. They needed to consider that the child's right to family care is fundamental and that children whose parent is jailed suffer serious negative impacts, which happen to include drops in school performance. They need to be able to show that the child's overall best interests and enjoyment of their rights will be positively affected by jailing the parent, and they must show that less extreme measures do not make enough difference to school attendance. They need to show that criminalizing parents has effectively resolved absenteeism elsewhere, so we can expect that this actually will do the job, and because what they're suggesting is not the start of criminalizing parents but an increase in penalty, they need to justify that increase in penalty and be able to say there's research suggesting that 12 months will work better than the previous 6 months in the law. Later on, we'll look at what they actually did. But first, we need to consider some other important points. When a Department of Basic Education does or does not embody full respect for human rights in all of their levels of practice, these ethics have an exceptionally high impact on the whole of the national culture. Firstly, their own practices directly shape the understanding, experience, and expectations of the bulk of the population during their most impressionable formative years. This is called the hidden curriculum or the meta-curriculum. What do children experience in the classroom? They often spend as much or more time interacting at school than with their own parents, and the school environment is central to the formation of their concepts of what is normal. So you have generations of your citizens going through this enculturation process, this socialization process. People often think that socialization in schools just means the kids get to play with friends. It actually means they get shaped to have certain expectations in a certain place and time. Most adult citizens actually end up having more direct contact with schools than with other state departments in many circumstances. And last but not least, basic education teaches the nation what is fact versus fiction. In this way, it's obvious that the duty to promote rights does not affect every state department equally. The Department of Basic Education has an exceptionally particular duty in this regard, in that along with state media channels, it is positioned to shape public understanding more than any other department. And we should therefore expect the DBE to actively ensure South Africans understand human rights and that our young people know their rights. And therefore, yes, human rights should absolutely be part of any curriculum if there's going to be a defined curriculum. However, the DBE also has an exceptionally particular duty to respect, protect, and fulfill rights. Human rights in general, and children's rights in particular, must be more than just part of the curriculum because they must be learned through experience. And as I said earlier, this is a thing that most people don't realize, so it has been increasingly spelt out. Human rights education should provide information on the content of human rights treaties. That would be something in the curriculum. But children should also learn about human rights by seeing human rights standards implemented in practice, whether at home, in school, or within the community. Human rights education should be a comprehensive, lifelong process and start with the reflection of human rights values in the daily life and experiences of children. Human rights education can shape the motivations and behaviors of children only when human rights are practiced in the institutions in which the child learns, plays, and lives together with other children and adults. Every organ of society shall strive by teaching and education to promote respect for human rights and fundamental freedoms. And human rights education and training is essential for the promotion of universal respect for and observance of all human rights and fundamental freedoms for all. Human rights education and training encompasses education about human rights, which includes providing knowledge and understanding of human rights norms and principles and the values that underpin them and the mechanisms for their protection. It also encompasses education through human rights, which includes learning and teaching in a way that respects the rights of both educators and learners. And education for human rights, which includes empowering children to enjoy and exercise their rights, as well as to respect and uphold the rights of others. In other words, human rights education must happen through lived experience, and therefore for the DBE to fulfill their obligation as the key department fulfilling South Africa's obligation to respect, protect, fulfill and promote rights, the DBE should be even more committed to human rights best practice than any other department. At the very least, the DBE should be very careful to respect, protect and fulfill the full range of human rights and children's rights, since this is key to promoting or educating on rights. So while it is a serious problem for any department to be dismissive of human rights, it's an even bigger problem for contempt for rights to become part of the core culture of a Department of Basic Education. It is my perception that the contents of the BELA Bill, as well as various incidents and aspects of the 7-year public participation process, show that South Africa's Department of Basic Education has shrugged off their obligation to uphold human rights best practice. The DBE currently holds children's rights in contempt, rather than shouldering their obligation to educate children on their rights through offering them a lived experience of their rights. Why do I say this? It's a pretty strong thing to say. Respect means that the DBE must not interfere with or violate any rights of the child. The DBE must allow and actively support the child to enjoy the right to an educational experience that is child-centered, child-friendly, and empowering. In order to educate the child on their rights through lived experience, the DBE must also allow and actively support the child to enjoy not only their right to education, but also all of their other rights, including but not limited to their rights to life, to liberty, to safety from physical violence, emotional abuse and neglect, their right to peaceful assembly, which includes peaceful protest, their freedom of expression, thought, conscience and religion, which also applies to things like choosing curriculum or choosing what to study. Family care is an enormous right for children, compares to the right of liberty for adults, in that it actually gives the child the safety and the love and the grounding to be able to thrive. The right to play is hugely important, and I'll talk about that in a separate place because it deserves its own focus. The right to privacy, to proper disability support where necessary, to have their own views, to be heard in decisions that affect them, and the right to participate in decision making on everything that affects their lives. It's beyond the scope of this presentation to look at violations and neglect by the DB of all relevant rights. I'm going to confine myself to a few that are directly linked to the bill, Clause 2. But before we get into that content, it's really important to note that the DBE had an obligation to respect, protect, fulfill and promote the right of their public school learners to be involved in the BELA Bill process. Not only did they fail to consult with learners when drafting the contents of the bill, they also neglected to support learner participation in public hearing opportunities. On top of that, a number of young people at public hearings were treated in humiliating ways when trying to participate, and this is where the DBE will say that's not their problem, it's the problem of the NCOP. Then we must look to the fact that the chair was an ANC member perhaps, and part of the Education Portfolio Committee. I don't know enough about politics to know where these lines are. However, they didn't exactly rein him in. The members of the DBE who were sitting there didn't protest or call points of order. And worst of all, the chair even tried to persuade the National Council of Provinces and the public that South African law requires that under 18s should be actively excluded from having any say, when in fact both national and international law says exactly the opposite. This is gaslighting in the extreme, and nobody from the DBE corrected him. To have their own views, to be heard in decisions that affect them, and participate in decision making is the right of all children. Public participation is premised on the belief that those who are affected by a decision have a right to be involved in the decision making process. And you will find that there are a number of links that you can click, that I clicked there by accident, that will actually take you to the places in this text, so you can go and reality check all the stuff yourself. Children have a right to actively participate in decisions, processes, programs and policies that affect their lives. This participation of children depends on the state and all organizations working with children and families to protect, respect and promote the rights of children. The Constitution of the Republic of South Africa affords all people in South Africa with the rights to freedom of expression, association, peaceful assembly, access to information, as well as the right to participate in public processes, and it gives full recognition of children's rights at the very highest level. The South African state has an obligation to protect, respect and promote the right of children to participate in decisions that affect them. Children should be able to contribute to the development of relevant legislative reform. It couldn't be more clear. The South African government is duty-bound to actualize children's rights to be heard in matters that affect their lives. It's also beyond the scope of this presentation to discuss the many other ways that the public participation process of the BELA Bill has been problematic. So for now, let's just notice that the rights of young people were not respected, protected, fulfilled or promoted by the DBE during the BELA Bill process. Young people have an enshrined right to participate in all decisions that affect them. Civic participation opportunities are internationally recognized as a very valuable part of education. Young people are the group of people most directly affected by this bill. Many of South Africa's education system's most urgent problems, such as classroom discipline, can only really be solved with young people's input, also beyond the scope of this presentation, but I'd love to give you some serious opinions on that sometime. So all in all, the DBE should have made excellent use of the opportunity to include young people, but instead did the opposite, displaying contempt for learners' rights as well as contempt for the DBE's own legal obligations to respect, protect, fulfill and promote these rights. And I've been pointing this out since 2017, so now it's time to just move on and have a look at the different parts of Clause 2. There's actually plenty of other clauses that I think are also profoundly problematic, some of them in exactly the same ways, but this presentation is already going to be way too long, so let's just try to stay on track here and focus on one place with a couple of sections. And let's use this template to try and keep us on track to the obligations outlined in the Constitution. So we've got to look at how does the clause impact the enjoyment of one or all rights, in what way, what purpose has been stated for having this amendment and who benefits if it's achieved, what are the relative impacts of achieving or not achieving the purpose compared with the impact of limiting the rights, what evidence has the DB offered that no less restrictive means are available to achieve that purpose, and what suggests that limiting the right will reliably achieve the purpose, and what grounds are there to support the specific extent of interference as the correct amount truly needed to achieve the purpose. We'll start at the top of Clause 2 with compulsory attendance of grade R. The young child has a right to educational options and support relationships that are personally in their unique best interests. Good experiences at this age can create solid foundations for life, whereas traumatic or discouraging school experiences can sabotage learning with lifelong impact. This clause seeks to limit this right in that it prescribes one predetermined and imposed fixed group program in one type of setting for all children at a set age, rather than according to personal readiness and fit, and regardless of local circumstances on the ground in terms of resources and quality provision. In a country where pit toilet drownings and severe corporal punishment remain, even the right to safety from violence and the right to life may be limited by this clause. And in this case, I would strongly encourage you to look at what the BELA Bill actually says, and to remember that any verbal assurances made by departmental representatives actually just don't have any weight once that law moves forward on paper into a future where they are not in charge. What purpose has been stated for this clause, and who benefits in what way if it is achieved? The memorandum actually states no purposes. Everybody's assuming this is for the benefit of the children. But the only purpose stated in the social economic impact assessment is increased employment opportunities for grade R teachers and assessors. That is actually the motive behind this clause. Relative impacts compared with the impact of limiting the rights. Well, should the right to the child to an optimal education, safety, life, etc. be subsumed by the right of adults to employment? I don't know. What do you think? Moving on. So, what evidence is offered that no less restrictive means are available to achieve the purpose? It is obvious that less restrictive means are available. Grade R provisions could still be progressively rolled out, employing more teachers and assessors, with a focus on making grade R attractive and accessible to young learners and their families, rather than relying on coerced attendance. Grade R teachers could be trained as mobile coaches to circuit and support and train families and small neighborhood groups in optimal ECD provision, which could achieve the never stated purpose of improving early childhood stimulation for children not attending formal programs, either because they're not able to, because there is nothing, or because they're not ready to or don't prefer to. What evidence suggests that limiting the right will reliably achieve the purpose? No evidence has been offered. Given that overcrowding is rife in public schools and that the DBE still has significant numbers of learners without places in higher grades, it's actually not really clear whether a significant number of new jobs will be created or whether existing grade R teachers will simply receive a higher load. What grounds are there to support the specific extent of interference as the correct amount truly needed to achieve the purpose? Nothing suggests that coercion of all 5-year-olds to attend formal grade R programs will generate enough budget to employ a significantly greater number of grade R teachers and assessors, as it is only attendance that is coerced from these families, not payment. Employment of more educators does not depend on higher demand that results from coerced compliance by children, but on allocation from the national budget. So let's do a little bit of discussion about this. A lot of people don't really realize that a lot of the research that one looks up online is based on, well, a lot of it is desktop research that's based on previous desktop research, which means that people read articles written by people who read articles, who read articles, who read articles based on research that maybe isn't quite as solid as people think. So it's quite important to go all the way down that rabbit hole when deciding that you've got evidence for a certain program, especially when it comes to early childhood education and pre-K and all of this stuff. So here's a quote: "Convincing evidence of the longer-term impacts of scaled-up pre-K programs on academic outcomes and school progress is sparse, precluding broad conclusions. The evidence that does exist often shows that pre-K induced improvements in learning are detectable during elementary school, but studies also reveal null or negative longer-term impacts for some programs, and some of those impacts are also behavioral. Again, beyond the scope of this presentation, but we don't need more kids with issues breaking, with issues with behavior and acting out. Right. So not only has the DBE failed to provide us with evidence that the planned CAPS-style grade R will actually improve young children's later academic success, it's not clear to me that they would be able to do so even if they had bothered to try, since the CAPS grade R program imposes teacher-led, structured activities on relatively large groups of children. And while these activities may look good on paper, I mean, their workbooks look awesome in many ways, although there's also other problems that I'll highlight in different places. A study conducted by the University of Stellenbosch in 2014 found no discernible benefit for South African children attending grade R in the bottom 3 quintiles, suggesting, as usual, that the main benefit actually comes from things that can't be dealt with in a scripted lesson plan. And the workbooks are resource heavy, requiring things like full-length mirrors, unlikely to be available to every child in a rural area. They're scripted and prescriptive. They require multiple items, and they also say things like the teacher can move backwards and forwards in this workbook according to the readiness of the learner, which is just not possible when you have a certain number of learners in your class, especially when they are very young and very busy. So this doesn't look very realistic to me. And then finally, the only research study that I personally was able to find, please do send me links, I would love to read more, but the only one I could find that's really got evidence for enduring results that are good for both academic preparation and behavior and self-management and all of this stuff is the TOP program, which actually uses an adaptation of the Reggio Emilia approach, which is pretty much the opposite of CAPS. So, yeah, I suppose I didn't say, I think I'm going to say in a minute what's different about it, but the point is that it's child-led and emergent and relationship intensive between facilitators and children. It's not about scripted lesson plans and activities. Yeah, there we go. So, forcing them into a particular kind of grade R could actually negatively impact or endanger a range of their rights and limits their right to the kind of education they're really supposed to be getting. Because the non-graded age-mixed approach with emergent child-led curriculum actually seems to offer the best results. Now I get that that's not accessible to every child in South Africa, but why coerce those who can get it to get something else, especially given that you could, as I pointed out, actually empower this approach to be something that people could learn. So I would propose solution for BELA: remove the amendment seeking to make grade R attendance compulsory. It's not necessary. Keep rolling it out. Go ahead, do your CAPS program if you want to, but I would rather see existing Reggio practitioners partnered with to create resource materials that could be used for guiding parents and caregivers, as well as existing grade R teachers, so that they could actually not have to only rely on scripted workbooks. And you could use public media and social media channels, as well as traveling resource workers and mobile toy libraries. I mean, why are we not using mobile toy libraries? It's just a no-brainer. They could have all sorts of extras on board, like a clinic sister and some nutrition stuff and you know, a social worker. I mean, wow, just equip that bus and send it out there. Much cheaper than trying to build extra grade R classrooms everywhere and transport each little child to the place. It's like, send it to where they are. But that's part of my mission, which again I'll talk about somewhere else. This would also meet the need for more employment opportunities, absolutely, and it could also create employment on the ground for communities instead of shipping highly qualified people in at great cost. Upskill where you are. Right, moving on. Enough about that. I know that the grade R one's going to be very controversial. I don't think these next couple are going to be as controversial, because I think a lot of people are very invested in the grade R program as it stands, whereas this here just doesn't have foundations, right? So, increased sentence for parents who don't cause a child to attend school. How does this clause limit the enjoyment of one or more rights, and what are the possible impacts? Well, it's a bit of an obvious one. Parents have the right to liberty, and restricting that has many other impacts on a whole range of rights. Children have the right to family care, and the same applies. And the family also has the right to choose the form of education. Research shows that children whose parents are in prison suffer a wide range of serious harms, including heightened rates of school failure. Both parents would have to be imprisoned. It says responsible for, but anyone who's helped create a child is responsible for the child. So then that child has no parents, leaving the child as a burden on the state, and the state may have to work quite hard to track down and arrest absentee fathers, because a lot of families where the child's not attending school are going to be families in distress, and often single parent homes. We won't even go into the question of child-headed households. What purpose has been stated for the clause, and who benefits in what way if it is achieved? The memorandum does not state any purpose for this amendment. Nothing. It pretends to. It says that the purpose of the sentence is to act as a deterrent for parents preventing a learner from attending school without just cause. I'll go into that wording in a minute because it's misleading. But no rationale is offered for the actual amendment to increase the sentence. The closest to any research or case study offered in the SEAS refers to the burning down of schools in Limpopo, which did not involve parents except those parents who were trying to protect the schools. There's this mishmash of justification behind Clause 2 in the SEAS that actually doesn't end up offering anything specific for this particular amendment. What are the relative impacts of achieving or not achieving the purpose compared with the impact of limiting the rights? Well, a number of experts have argued against this amendment, and I'm not going to go into all of those arguments. It's already pretty clear. But the bottom line is that given that children whose parents are jailed are at a higher risk of specifically school failure, there's actually no evidence to suggest that jailing parents, especially for longer, will support the child's fulfillment of the right to education. So, what evidence is offered that no less restrictive means are available to achieve the purpose? Well, no evidence has been offered. And there are a number of less restrictive means available to increase school attendance, such as just one suggestion somebody came up with, which is obvious, is the creation of a truancy officer role, which would also create employment opportunities. And then all the research looking at what impacts school attendance. There's so many factors. And poor school conditions, many different aspects of poor school conditions are detailed in the research. So yeah, perhaps the DVE should first successfully improve school conditions and see how much difference that makes, because it's likely to make a very big difference. And that would result in a fulfillment of the rights to education rather than a limitation of rights. What evidence suggests that limiting the right will reliably achieve the purpose? No evidence has been offered to suggest this. No attempt was even made, and significant evidence suggests that it will not. What grounds are there to support the specific extent of interference as the correct amount truly needed to achieve the purpose? Well, there's no research shown that a 12-month sentence will be more effective in ensuring school attendance than a 6-month sentence. It's important to note that earlier versions of the BELA actually proposed a 6-year sentence, also with no apparent rationale other than a kind of authoritarian relish. So this was actually raised by Section 27, and they requested that in relation to the criminalization of parents who failed to cause their child to attend school, Section 27 notes that this is ineffective. It's against the best interests of the child, which in our law has to be paramount in all decisions about the child, and it has the potential to disproportionately prejudice mothers in particular, because they're going to be the ones who are found, because they're the ones usually, most cases, still actually committed to caring for the child. We recommend that these kinds of criminal sanctions on parents be completely removed. In the event that they are kept, we note that these have to be made subject to certain considerations to make sure that the best interests of the child are protected. So we need much more detail in the law, exactly what kinds of circumstances could justify criminalizing the parent. We can't have it as vague as it is in the South African Schools Act and in the BELA. So the whole reply from the DBE on the 20th of March 2024 was that the amendment may not be removed to give effect to compulsory education, with no undertaking to add any safeguards at all. To deprive a child of their parent in order to tick a bureaucratic box around the form of education that child receives is unconscionable. Even the threat of jail time for a parent is traumatizing to a child, and I've repeatedly seen in the last 7 years a number of children have been terrified on hearing about the BELA Bill, and a significant number of families have avoided involvement in the hearings. They won't even speak up for their rights because they're frightened of marking themselves out as targets for revenge once the bill passes into law. That's the kind of effect that this is having on our citizens. Continuing this discussion, on the one hand, aiming to use this clause as a deterrent without ever actually jailing anyone will simply create more contempt for the state and undermine respect for the law more than it already is. On the other hand, using this clause to arrest a small number of parents in order to set an example will violate the rights of the families affected. Using this clause to intimidate parents into betraying the best interests of the child by forcing them into suboptimal education provisions in order for the DBE to postpone or avoid the obligation to improve the quality of public education provision, instead aiming to intimidate families into just accepting whatever is provided, constitutes, I'm going to say the word intimidation, in that it seeks to use a deterrent not to prevent a crime, but seeks to use a deterrent to prevent the child from enjoying a number of their rights, including but not limited to their right to use academic freedom in order to fulfill their right to education in personally optimal ways. Their right to safety and freedom from violence. In all of the responses from young people that I helped collect back in 2017, a huge number had left school due to abusive teachers and peers, whereas this seeks to just shove them back in. Their right to disability support, since many children also leave school because of persecution and for lack of necessary accommodations and more. And here's a lovely quote from Professor Visser, University of Victoria, years ago, still true and always will be true, that obliging parents to send their children to poor quality schools makes a mockery of what compulsory education is all about. And this is where I really feel that human rights wording is being seriously abused here, and we'll go into more of this later. Alright, we keep going to the links that I keep accidentally clicking on. Right, so the memorandum which explains what the BELA Bill is about, and it's often the only thing people can manage to read because the rest is not an easy task to chomp through, falsely claims that Clause 2b.a applies to the parent who prevents such a learner from attending school. But the actual clause in the South African Schools Act and the BELA deal with a failure to cause a learner to attend school, which is not the same thing in any way. Cause and prevent are opposite concepts. This is really important because a parent who prevents attendance is far more likely to actually be interfering with the child's rights, which then does oblige the state to set in. Where a parent who fails to cause the learner to attend might be interfering, sure, but they may also be protecting the learner's rights, depending on the potential dangers and impacts on the learner of attending that school, or they may simply be struggling and lacking capacity and needing support in some way, which is also where the research shows that social support is far better at getting children into classrooms than criminalization. But it doesn't look like anybody read that one. Substituting the word prevents in that memorandum, which everybody gets to read, actually influences decision makers to see this clause as more reasonable than it actually is. And at some public hearings only, the memorandum was made available. There's also been lots of propaganda about this in the media, which I'm not going to go into here and now. But with no rationale offered by the memorandum or the SAYAS, I had to turn to media statements and verbal statements by the DBE at public events to find out what they were actually thinking when they decided to do this. And this yielded at least two intentions, which would fall under definitely not preventing attendance, but failures to cause attendance due to purely a lack of capacity, rather than prevention of attendance due to neglect or abuse of the right to education as such. The first is this continued repetition that was made again on the 20th about parents using their children to beg at traffic lights. We're going to jail them because it's not okay. This is where we have to take into account that this education department is not politically neutral. It is part of, the MECs and so on. They are appointed by a ruling party, which has, there's a network of responsibilities here, state responsibilities. And if you're going to have the numbers you have in South Africa of children dying of malnutrition and hunger, then you cannot jail parents if their only possibility of feeding those children, when school feeding programs have also not delivered, is to get their children to beg at traffic lights. And well, this just smacks of something I'm going to talk in a minute, but yeah, not okay. And the other one that came up at the public pre-hearings workshop at the Gauteng Provincial Legislature was the example of parents who are struggling with substance abuse problems. So parents struggling with substance abuse problems, again, addiction is a very complex thing that's got a lot of causes and influences, especially in the circumstances that most people are in now with unemployment and stress and trauma. And many addicted parents love their children and are doing their best to care for them, but there's a reason they're addicted, and that has to do with their struggles, and they might not be managing to get them to school, and social support would make all the difference. I also want to just a side note here that it's also often undiagnosed neurodivergent parents and children who are going to have the hardest time getting to school, especially the kinds of schools that are offered in the public system, which means that we're going to be targeting them disproportionately as well. Now this is where I have to take yet another deep breath, because what I'm about to say again is a big thing to say, but I am going to say it because I have to say this. So this suggests to me that the DBE either does not understand or does not respect or care about the difference between the state's obligation to protect the right to education by interfering in cases of bona fide interference with the right to education, and opportunistic abuse of state power to perpetrate human rights abuses on already vulnerable victims as an expression of privileged and arrogant authoritarian entitlement and prejudice, which we could also translate into the one word bullying. This is evidence of a very serious problem within overall DBE culture that goes far beyond discussions of the BELA Bill. Authoritarian attitudes that normalize severely abusive behaviors, such as jailing vulnerable people because you can, cannot be allowed to provide a foundation for any state department. As pointed out at the start of this presentation, it is even more critical for the Department of Basic Education to deeply embody human rights best practice than it is for any other. Let's notice that this is the kind of attitude driving the worst instances of so-called corporal punishment. As above, so below, no wonder it is so hard to get rid of corporal punishment on the ground. How do we expect teachers to use positive discipline when the DBE models abusive attitudes like these from the very top down? The severe lack of empathy embodied in this amendment suggests that it may even be advisable to consider listing a number of DBE policymakers with the Department of Social Development as people unsuitable to work with children. Okay, it's easy to provide solutions. Rather amend the South African Schools Act while we're here amending the South African Schools Act to get this right. So we need to change the wording so that the current penalty that's already there only applies to parents who prevent the child from fulfilling their right to education, and not to the parent who fails to cause a child to attend school. This would fully allow for human rights aligned state interference in cases of bona fide educational abuse and neglect in order to protect the child's right to education, without incentivizing bureaucratic or opportunistic political abuse, and not incentivizing the DBE to further neglect the obligation to improve public school conditions. And together with that, remove the change in penalty. It's really not necessary. And then together with this, a proposed solution for South African education, because that really ought to be our focus, even in an administrative and bureaucratic bill, right? Research actually links student empowerment and collaborative discipline with dropout reduction. Aha! And improved classroom culture. So how about instead we partner with experts and practitioners to actually implement as well as extend the plans for the learner representative councils that often haven't been rolled out or just token tick boxes, and other structures for active learner participation in school governance so that learners are able to take ownership and collaborate in improving school conditions. I know that it's hard to believe, but this really makes a difference. Also, create increased participation opportunities for parents, teachers, community members, local businesses, and other stakeholders to be able to collaborate in improving school conditions and providing support for vulnerable families. Empower and encourage microschools, informal educational support initiatives, and home educating families to share their secrets of success, and take inspiration from flexible and mobile options, such as traveling teachers provided to nomadic groups in some countries. Because we need to creatively innovate and revitalize the South African education landscape so that all learners have access to options that support them in fulfilling their right to education in personally optimal ways, regardless of the challenges to their life circumstances. Children who are currently forced to choose between starvation and education should have educational support that comes to where they are, rather than having their last source of care removed from them. Each one teach one. We've got enough people sitting around with nothing to do, and we absolutely can benefit from a beautiful let's collaborate and come together from our kids. I think South Africans have got that in them, and I think we can absolutely do it. Oops. Let's just head back to the previous one. Okay, so now here we come to clause 2BB, which is a little bit quicker and more straightforward. And there's not a huge argument for me about this one. It's just, again, it's not justified. It hasn't gone through any kind of due process, and it just doesn't make sense, right? This increases the sentence for any other person who prevents a learner from attending school, and it does use the word prevents, which makes it legitimate. Right? any other person who, without just cause, prevents a learner who's subject to compulsory attendance from attending school. We won't go into that compulsory attendance phrase in this presentation. I will be coming back to it. But yeah, how does the clause impact the enjoyment of one or more rights, and what are the possible impacts? Well, the right to liberty is removed for double the length of time. And again, it was 6 years, I think, in a previous version. What purpose has been stated for this amendment, and who benefits in what way if it is achieved? So this is where it gets muddy again, because the purpose, as explained in the socio-economic impact assessment and the memorandum, is once again not addressed clearly and specifically on its own, but rather as part of the mishmash of justification for Clause 2BA, Clause 2BB, and Clause 2C combined. The intention to increase the penalty provision from 6 months to 12 months was to ensure that the penalty provision should serve as a deterrent for any person who interrupts school activity. The amendment is necessitated by incidents in several provinces in which communities or portions of communities prevented learners from attending school in an attempt at making a political or other point. Fires in Limpopo are then mentioned thereafter. I'll discuss that in detail under Clause 2C. What are the relative impacts of achieving or not achieving this purpose compared with the impact of limiting the rights? Well, no attempt has been made to contrast the impact on prisoners kept for longer with the expected impact on the child of being prevented from attending school. They just don't go to that level of, effort. So, what evidence is offered that no less restrictive means are available to achieve the purpose? Well, I don't know who's preventing school attendance and why. We kind of need to look at that first, don't we? Because if we don't know who's preventing learners in what way, and we haven't cited any research on the situation in South Africa, and we don't have prosecutions that show that 6 months didn't work and 12 months would, then there's just no evidence to suggest that increasing the sentence will change anything, right? So is it the right amount of time? Who knows? Let's suck something else up out of our thumb and put it in a law. Am I missing something? But it seems to me to be increasing the sentence in the hopes that it will make some useful difference, whether there's any reason to believe that it will or not. But the important thing about 2BB, this is important for when we come to our next slide. Let us note that this clause absolutely does completely cover all cases where any person prevents a child from attending school. I'm going to actually go backwards so that you can see that very, very clearly. Any other person who, without just cause, prevents a learner from attending school. That is there in Clause 2BB. So what on earth is the point of Clause 2C? This criminalizes the interruption of official school activities. So how does this clause impact the enjoyment of one more rights, and what are the possible impacts? Well, obviously, a criminal record can negatively affect a person for their entire lifespan, and the loss of liberty for just 1 year impacts a range of other rights and interests both for the person incarcerated and for any of their dependents, as well as for any employees or employers. And if used as a deterrent to prevent a person from exercising the right to peaceful protest, then this clause will constitute intimidation. Again, a deterrent is meant to prevent a crime, not the exercise of a right, and there is a right to peaceful protest for good reasons. What purpose has been stated for the clause, and who benefits if it's achieved? Again, the memorandum has only got the mishmash, right? Necessitated by incidents in several provinces in which communities or portions of communities prevented learners from attending school in an attempt at making a political or other point. Schools burnt down in Limpopo and Vuwani. I think that's 2016, like 24 schools or something. It was horrific. And if this were truly the purpose of this clause, then ostensibly learners would benefit from uninterrupted lessons, which could protect their right to education. Fair enough if that was what was going on. But there's no point in carrying on with this template, because it's patently obvious that this is not the actual purpose of this clause. Why do I say that? Well, firstly, incidents in several provinces in which communities prevented learners from attending school. So the memorandum is falsely claiming that this clause deals with the prevention of learners from attending school. It doesn't say that. It's not about prevention of learners from attending school. It's about interruption of school activities, right? Because prevention of learners from attending school is already completely dealt with in 2BB. So if that was true, clause 2C would automatically be a redundancy with no purpose whatsoever. There's no mention of preventing attendance. It says, any person who unlawfully and intentionally interrupts, disturbs or hinders any official educational activity of a school, or hinders or obstructs any school in the performance of the school's official educational activities is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 12 months or to both a fine and such imprisonment. So Clause 2C doesn't deal with the prevention of school attendance, also because any child not at the school would not be affected by any interruptions taking place while they're not there. So why would the memorandum claim that it does? Just incompetent drafting? Or an attempt to camouflage the actual purpose of Clause 2C? So Clause 2C also is not there as claimed in the socio-economic impact assessment statement to prevent a repeat of the events in Vuwani, Limpopo. The instigator of the Vuwani school fires, who was an ANC ward councillor protecting his perks, was prosecuted on a charge of public violence. They could also have prosecuted him for malicious damage to property, both of which could see him get a lot more than the 12-month sentence now detailed in Clause 2C. There's no need for the Schools Act to have to criminalize things that are already provided for in criminal law, especially now that it comes with a smaller recommended sentence. I was curious to wonder what was his sentence, because I actually couldn't find it. Would be curious to know. If you know, please do tell me, just for my curiosity's sake. But why has the DBE spent 7 years without transparently providing a plausible purpose for this clause? What on earth is it actually for? So this clause allows for at least 6 purposes, all of which are deeply disturbing from a human rights perspective, and nobody I know has been able to come up with any possible purpose for this clause that isn't deeply disturbing from a human rights perspective. If you can manage it at the end of this presentation, again, please do let me know. So, what is the purpose of Clause 2C? Well, I did ask, and I didn't get an answer. What we do know is that the DBE is determined to keep this clause and consistently draws attention away from it. They don't like mentioning it too much. The memorandum's not accurate. They refuse to explain why it matters to them. Why is this important to you? Because it's not about the fires in Vuwani. It's actually a kind of Swiss Army knife of a clause in that it can be used to do at least 6 things. Here are the 6 things I can see that it can do. Number 1, it can be used to jail political opponents of the ruling party who don't see it coming. Number 2, it can be used to prevent parents, teachers and learners from protesting about school conditions when nothing else has worked to fix things. 3, it can be used to criminalize learners in place of corporal punishment and positive discipline. 4, it can criminalize learners in place of properly providing tailored options and disability support for neurodivergent learners as well as for various kinds of vulnerable learners. And it can criminalize learners to provide income for the corrections department, and it can prevent climate Fridays and similar student action initiatives. Now, all of this sounds very far-fetched. I acknowledge that. However, unless we can come up with a plausible, transparent, real reason for the importance of this clause to the DBE, we have to consider that maybe it's not as far-fetched as we think. So let's have a look at these in detail. Firstly, interruption of official school activities. Public Interest Law Centre, Section 27, also spotted this problem and asked that it be removed. They said the wording was too broad. Oh, there I go, opening my links again. So I've put the link for the recording here so you can see their presentation. Oh, in fact, that's coming in a minute. This is the link to the DBE's response to their presentation. Separate occasion. It really helps to separate questions and answers if you're going to obfuscate. Would have preferred to see throughout this process the DBE responding directly after any comment at any point and with an opportunity for interaction. It would have been much more revealing. So the DBE summarized it like this. We submit that the creation of a new penalty for this in clause 2 is too broad and may negatively affect a range of constitutional rights. Remove this amendment. That's all you'll see on the screen when the DBE is doing their response. So there's no clue to viewers what this is that's referred to that they're asking to have removed. Take away the context and you can give it more spin. Then here's the link. Shows what they actually said is in relation to the penalization of persons and protests that obstruct or disrupt schooling. We know that there is a need to prevent protest action that is disruptive, that will infringe upon persons' rights to basic education, and that they should be penalized for this. But we submit that the creation of a new penalty for this in clause 2 of BELA is too broad and runs the risk of violating a range of constitutional rights. I would put it that it's more than a risk. I can't see any way you can use this clause without violating any constitutional rights. They said, we know that there is a host of existing law that penalizes persons participating in protests already, and we feel that there should just be greater enforcement of these laws, and that this amendment be removed entirely. Very sensible, important, and well-founded recommendation, which didn't even draw a comment. You can go there and watch the little awkward pause. That is the only acknowledgement that this is not being dealt with. The written slide says the amendment may not be removed to give effect to compulsory education, which is a cut and paste from their response to 2B. So both the memorandum and these responses simply cut and paste the same response for completely different clauses, as if they're the same thing when they're just not. So, first possible purpose, criminalizing peaceful protest by political opponents of the ruling party. So this clause can be used to criminalize any protest that is actually conducted completely in accordance with the law in every way. All you have to do is show that school functioning was disturbed in some way. So the ANC could actually arrest Mr. Malema next time that an EFF protest calls for a school shutdown, just for example. And under this clause, organisers themselves can be jailed rather than the police having to actually track down individuals involved in things like looting. So it could really easily be abused to target political opponents and up-and-coming community leaders who have not been made aware of it since it's hidden in a basic education law. If it were tabled in a more honest and transparent way in a law directly relating to protests, there might have been an uproar. But over here, it's just quietly there, looking unproblematic to most people. What purpose has been stated for the clause and who benefits? Well, there's no statement from the DBE that accurately states its purpose, because they try to make it seem that it's got to do with protecting school attendance. We can help them along by saying that it prevents school disruption occurring, as they say, because of communities or portions of communities attempting to make a political or other point. And service delivery protests were mentioned in DBE media releases. But given that it's not acceptable to jail peaceful protesters who disturb hospitals, where people might die as a result of the protest, it can hardly be considered appropriate to criminalize people who are disrupting a lesson or two, especially given other things that we can talk about shortly. So if the purpose is to criminalize peaceful protests otherwise conducted in legal ways, then achieving that is a violation of human rights law, because people have a right to peaceful protest. and when those protests are peacefully conducted in a responsible manner, people should not be going to jail for them. How can we assess whether limiting the right will achieve the purpose of not seeing schools disrupted? Well, given that the penalty hides within an education bill, it's actually very unlikely to act as a deterrent for school disturbance, unless the DBE undertakes an extensive publicity campaign, or unless you share this presentation far and wide. And this makes it potentially useful for ambushing political opponents and extracting community leaders who could be considered to be problematically influential. But it's not particularly useful for actually preventing disruptions to schools, at least until the first high enough profile case hits fairly big headlines and everybody finds out about it, which isn't as easy to achieve as you might think. So on my WhatsApp, I'm actually part of a national traffic and protests group, and I see a number of protests. Almost every day there's more than one somewhere in South Africa. Very few of these hit the news. Even when you see, oh, avoid this road because there's bricks in the road and rocks being thrown and tires burning, I don't see things like that in the news on those days, because they concern very marginalized, politically disempowered communities who are out of the way of people who are going to be taking photographs and putting them in the media. So actually many small level local leaders of such protests could be jailed under this sneaky clause before the whole of South Africa became any the wiser. Okay, yeah, and they don't have to throw rocks to do it. All they have to do is make a bit of noise at the school, or slow down a taxi so that the learners are late, or something like that, and off they could go for a year. How do we know that the specific extent of interference is the correct amount to achieve the purpose? Well, who knows whether the point would be to simply arrest and release as a deterrent, or to extract leadership from the community more thoroughly. It might vary by circumstance. We could imagine how soon is that particular leader due to have another impact, or maybe even stand for election. It could be very handy to be able to extract people surgically at particular times in their careers. It would also depend on whether or not a criminal record might disqualify them from some key position, or whether a prolonged absence is needed to do the job. Who knows? Who knows? So, further discussion. How does this impact the enjoyment of one or more rights? Well, in addition to the loss of liberty and family care, which in themselves compromise a host of other rights, this one can directly compromise the right to education, because this time we're looking at peaceful protest by parents, teachers and learners, when the DBE renders all other avenues fruitless. And we have seen a lot of complaints about this, that dispute resolutions, begging and pleading, reminding, quite often don't work. If it was used for this purpose, then the DBE would benefit from being able to easily silence pushback for its failures. Because if we look at peaceful protests and school shutdowns that have taken place, if you just scan the news over the last couple of years, just a couple of examples would be people insisting that heavily overcrowded classrooms are not conducive for teaching and learning. We're going to shut the school until there's a decent number of kids in each class. Collapsing infrastructure, we're actually scared that our kids might die because these classrooms are multiple decades old and were badly built at the time and haven't been replaced. Horrific persistent assault by abusive educators in some places, really laying into those kids for things that they can't help, like for example failing a test or getting an answer wrong. And after years of this, parents coming and showing up at the school, and it's interesting to see what happens to them when they do. Well, that gets messy. So now here's a nice easy solution. One exact example at the public pre-hearings workshop, an SGB member from a township school explained how they had begged for chairs, sending multiple emails, waiting, I think he said 2 years, and it was only when they finally shut the school that the chairs got delivered. And there we go. He could be jailed under the BELA 2C. Given that the media also tends to follow protests more regularly than mere complaints, 2C could intimidate parents, teachers and learners who are planning a protest of some kind into cancelling their plans, which would help keep the problem invisible to the rest of South Africa. Another thing that happened at the pre-hearings, when somebody was asking, a community member was asking, please can you tell us exactly how we homeschool, because we've got all these kids that haven't gotten places and now we need to know what to do with them, and this clause here is not very clear. He was told to pass along the MEC's email address to these parents that he's aware of, with nobody in the room jumping up and offering to make sure that this happens. And no kind of sense of, oh, don't worry, because the MEC obviously is still trying to place them because she's aware of you, because you've applied. It was considered totally plausible that it would be necessary to notify the MEC that children who've applied are still not placed. So who truly knows the extent of failures to which the DBE turns a blind eye until they are forced not to? I don't know that, but the media doesn't suggest to me that that picture is very good. So clause 2C could be very useful for ignoring obligations with less pushback from the ground and also less damage to the DBE's public image. Continuing, the relative impacts compared to the limiting of the rights. Considering that parents, learners and teachers resort to protesting about failures of educational service delivery only because the DBE's additional failure to make other avenues of resolution workable, jailing them for protest adds injury to injury. What evidence is offered that there's no less restrictive means? Well, implementing their own dispute resolution mechanisms effectively would be a desirable alternative to consider, as would prioritizing effective service delivery. And here's the secret, right? Involving learners and communities in collaborative problem solving for some of the insurmountable challenges. Instead of alienating learners, parents, SGBs and communities a la BELA, could bring about a whole new avenue for achieving quality provisions for education in South Africa and the fulfillment of the Freedom Charter's promise to open the doors of learning and culture to all. But yeah, then we need a different attitude to this attitude upon which the BELA Bill has been founded. And I've got a separate video where I was explaining my thoughts on this to somebody that you might want to look up, because I really do think we could turn things around, but then we have to stop heading up this particular horrible alley. Yeah, what evidence suggests that limiting the right will reliably achieve the purpose? Shoving an elephant under a rug is likely to leave a lump in the room. What grounds are there to support the specific extent of interference as the correct amount needed to achieve the purpose? So rather than achieving the purpose, it's actually more likely to up the ante, because you might as well be hung for a sheep for a lamb. So why keep your protests peaceful if you're going to go to jail anyhow? Why not torch the building? Which really then does have a problematic impact for the kids, right? And this is the universal problem with authoritarian approaches, is that they inevitably require escalation in order to have effect. And we're already very close to war in many of our public school classrooms. We don't need anything to make it worse. Next, criminalizing learners in place of rolling out positive discipline or reintroducing corporal punishment. Let's notice that there is a call to reintroduce corporal punishment because teachers don't know what else to do. And we even have Mr. Lasufi sympathizing there, and he is one of the champions of the BELA Bill. Now, learners have the right to child-friendly, empowering learning environments where they are active participants in positive disciplining processes. So far, the DBE has not managed to effectively roll out the envisioned positive discipline training for teachers, nor have they significantly explored models for true learner-teacher collaboration in the classroom, which I promise you can make such a difference. Arresting learners, even if they are simply given suspended sentences, can leave them branded as criminals for life, as well as harm their reputations in the community, and actually jailing them can derail their lives into permanent lives of crime or other forms of disaster. So just to be clear, what we're talking about here is we're talking about, instead of trying to give a learner detention, calling the cops to take them away, because that actually is allowed for by clause 2C. Stay with me if you think that that's far-fetched. I'm going to show you more. So in the USA, this type of law has seen literally thousands of students jailed and is used to justify and maintain socio-political divides in society for the benefit of the privileged. Given that teachers in South Africa are faced with increasingly overcrowded and unruly classrooms, many of those who have no idea how to move beyond corporal punishment might welcome the option of simply calling in the cops. Ironically, the harm done to learners could be even greater than that done by corporal punishment, and assault as part of the arrest, as has been seen in the US, could result in the same kind of physical injuries anyway. But hold it! There's no point continuing with C to F, because obviously this suggestion is beyond ridiculous, and this kind of speculation is just plain irresponsible, destructive, and verges on slanderous, right? Well, if you think it can't happen in South Africa, then why? Why is this extra sentence there in clause 2C? There's the long version. Let's try taking out the extra second sentence that really is there for learners. It could have just said, any person who unlawfully and intentionally interrupts, disturbs, or hinders any official educational activity of a school is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 12 months, or to both a fine and such imprisonment. As it stands there, it's already problematic, but it requires you to be unlawful and intentional. So what does it lose when we take out that second sentence? Nothing, really. It covers all the more legitimate cases that one could realistically justify prosecuting. But when you add this sentence, or hinders or obstructs any school in the performance of the school's official educational activities, that looks like a repetition. It's almost word for word for the first sentence, right? It's redundant. It's a waste of ink, except that it does a very particular job. So any person who unlawfully and intentionally interrupts, disturbs, or hinders any official educational activity of a school, or hinders or obstructs any school in the performance of the school's official educational activities. That or separates exactly the same offence from having to be unlawful and having to be intentional. You don't have to have meant to do it, making it perfect for disruptive learners who have no intention to commit an actual crime. They're not standing up and saying, I'm not going to let this class go ahead until wada wada. They're simply maybe acting up, maybe melting down, having some kind of argument about, who knows. I remember at school, when things were inaccurate in our lessons, it riled me and I wanted to make my point. I suppose now I could have gone to jail. So let's try another variation while we're here. Let's try doing what our Clever State in the USA did, and let's simply insert any person who is not a student. It's that simple. It's that simple. Could just put that in. At least it would protect the learners. Why did the DBE not already say any person who is not a learner? Why don't they do it now that has been pointed out to them? Because I did. I pointed it out weeks ago. Okay? My only response that I received was a reminder again that the bill is in the hands of the NCOP and yourselves to amend and improve the clauses. We will participate when invited. I'm inviting you. I have invited you. We have invited you. The invitation has been ignored. Why do you not want to protect your learners? Okay, I even pointed out to Mr. Ndebe that regardless of the DBE's current intentions, once the law is in place, exactly as happened in the USA, it could be used in this way by some later, more vicious administration. Laws hang around. So I asked, and Section 27 recommended, to remove 2C, and the amendment may not be removed to give effect to compulsory education. Why would the DBE? be so irresponsible as to make such a dangerous and ugly thing available and defend it in the face of opposition, given they could so easily change it to at least protect learners, if they have no intent to use it this way? I have to assume their intent to use it this way. It's the only way I can add this up. So yeah, it would be unconstitutional blatantly, but the DB here has said that they have already passed the BELA Bill through a process that says it is constitutionally compliant, exactly as it stands. So I'm guessing you have to prove in constitutional court that it's not. Do you personally want to give that a try? I'd rather not have to. Whew. Moving on to the next ramification, because when we look at who goes to prison under school disturbance laws in the USA, yes, it's your marginalized kids, your vulnerable kids, your poor kids, your black kids, your neurodivergent kids, your LGBTQIA kids, kids who talk back, kids who stand up against injustice. For example, the famous case is the one who stood up against her friend getting arrested or a classmate getting arrested. Teacher maybe doesn't like your face. Teacher does like your face, and you said no. That would be a big one in South Africa. Very handy. Nice bit of intimidation or blackmail or whatever available under this law there. Let's think about that carefully. Let's really think about that carefully. Able to act as witness to a teacher's dodgy behavior, being the victim of a bully who always sets you up to look like a culprit. Oh yeah, making the DBE's averages look bad due to being likely to fail the year again. Oh, what else could we do with you instead? Hangry from lack of breakfast, unable to cope with the sensory overload of being crushed in with 100 irritable peers, unable to avoid your meltdown. Making a fuss when your right to education has been absolutely betrayed by the school conditions you are forced to endure. But here's the argument. We don't have prison capacity, so why would we arrest extra people? That sounds like a safeguard, doesn't it? But, sorry to tell you, number 5 possible purpose is to criminalize learners to feed the corrections department. Stay with me here. Sounds unbelievable, but so what doesn't? So currently, prisoners in South African correctional services perform many kinds of internal work in their system. They've got their own farms, they've got their own factories, even manufacture their own shoes. They're as sustainable as they can get, and they're still struggling. What we're not aware of, most of us, is that many of our roads were actually constructed by convict labor. And now, while the country's falling apart and there's no budget for the potholes, how about a nice group of laborers that only has to be fed and given a bed and transported but not paid? That sounds like it could be a plan. But most convicts are not in great physical shape, and let's face it, how do you sort out which ones are dangerous? And then you're going to have them working out in public where they could do a run or something worse. So teens and young adults supplied by a school to prison pipeline could be younger, fitter, having committed no real crime aside from disturbing school. They'd be a much safer bet for public work gangs, wouldn't they? So while prisons are overcrowded right now, there are plans for thousands more beds in the next few years. And face it, our schools don't really know what to do with the 19 and 20-year-old learners who are unlikely to pass their matric even by staying longer. These learners are often restless and resentful as they face the fact of a bleak and difficult future, and they're more likely to act up in class. And they're a lot easier to arrest than actual criminals out on the run. And yeah, school disturbance laws in the USA, worded almost identically to Clause 2C, have indeed contributed to a system where students are exploited by the private prison industry and government prison systems which use cheap labor from students pushed out of school to increase their bottom lines. Because there's even more to this, right? Because another result of South Africa's struggling economy is that prisons themselves are also facing even further budget cuts. They need to bring in funds, money, not just internally manufacturing shoes. In the apartheid years, the South African government drew criticism from the human rights community for hiring out convict labor, essentially creating a kind of handy state slave trade. However, the South African Correctional Services Vision for 2030 is currently considering a return to exactly this practice. How fascinating. In response to budget constraints over the period ahead, the department plans to become more self-sufficient, by supplementing potential income streams by hiring out offender labor. Gosh, there's so many little pieces to this puzzle if you go looking down this rabbit hole. Now, if you were an employer getting cheap labor from correctional services, would you rather hire a healthy young 18-year-old who got emotional about losing his girlfriend, or a clapped-out 40-year-old actual felon? Which kind of hire is more likely to be profitable when they start making profit from the business sector? This could even be framed using propaganda techniques as sending youngsters into a system where they will at least acquire some skills as a result of their forced labor experience. And I can see people buying that. I can see them allowing it and thinking it's reasonable. It's not at all. It's a human rights abuse of the worst degree. So, here's a simple proposed solution for this. In South African education, it's kind of obvious. Studies are busy finding that youth volunteering is already increasingly popular and successful in South Africa because it does allow for kids to gain skills and have something useful to do and contribute to the community. So how about a partnership? Public Works and DBE. Open, honest, voluntary, right? It could be part-time, it could be full-time, it could have both. And the deal would be, while you're still at school, you could volunteer on weekends or a day a week where you go and learn some skills doing something useful for the society you live in, the place you live, and contribute to building the nation. And if you kind of feel you're going nowhere in the school system, instead of dropping out, you would have the option of going full-time into the volunteering option for a year or more, and until you felt ready to move on from it. But yeah, this could be a thing to explore. That would be a fulfillment of the right to work and contribute and learn, rather than abuse of the right to freedom. Next purpose, I'm not going to go into detail. It's kind of obvious, but 2C is perfect for this, and this is a problem that's growing worldwide as it becomes inconvenient for governments to be called out on their climate efforts. Clause 2C is perfect for criminalizing Climate Fridays and any other student action initiatives that come up, and South Africa tends to be kind of full of them. Swiss Army knife. Seventh possible purpose. Please tell me. If you feel that all of these purposes are far-fetched and impossible, please tell me. Once a law is in place, it can be used. And unless we can figure out the perfectly reasonable human rights respecting reason for Clause 2C to be worded exactly as it is, with that or, without who is not a learner, unless the DBE right now agrees to substantially change the wording to render it safer, or better, remove the clause, we have to assume the worst. Can you see any other applications? Who knows what the actual plans are, but there's something in there they're fighting to keep, or it would have been surrendered by now. So let's not worry about what the DBE plans to use it for. We don't know. But the lesson from the USA, it wasn't put there for the purpose that it's used for, but it became used because it was vaguely worded. So putting a vaguely worded law in place is just, there would be pushback in court, but this is important. South Africa has no costs orders in criminal cases. So if you storm into your child's school to demand justice for your teacher-impregnated daughter, and you're charged with a Clause 2C offence, and you hire a great lawyer to defend you, and the DBE drags out the case, in the same way they drag out many other engagements, you could be bankrupt by the time you are declared innocent. or if you happen to be an undiagnosed 20-year-old dyslexic grade 12 who stood up to a homophobic teacher in a poverty-stricken rural area facing a too busy judge who doesn't speak your language and his lunch is late, and the prosecutor is good with his spin, and the local corrections center labor for hire program is short of good, strong, able bodies, guess where you could go. How it will end up being used is not something I want to find out, but it's there to be used. Do you want to find out? So we are finally at the end of this presentation, which is long, but I don't know how to make it any shorter. South Africa has a history of abusing a labouring population criminalised by laws that we tried to abolish in 1994. Much of our historical wealth accrued as a result of the state as the provider of unskilled black labour for the mines through the penal system. Let's notice, the architects of apartheid exercised control over the population and exploited the people at the bottom for the benefit of those at the top precisely by using legislation to criminalize people by the use of carefully crafted laws that could put people behind bars for the commission of bureaucratic offences rather than actual crimes. In my view, BELA resurrects this legacy, using administrative and bureaucratic offences in punitive ways that can benefit the ruling party without increasing the safety of the people. One example, demanding an EMIS number without any regard for whether or not the micro school is actually providing optimal education. Only now that the DBE has actually responded to Section 27 2 days before this presentation, and other stakeholder presentations treated in the same way, is this really finally clear. I don't believe anymore that the BELA Bill should be considered in isolation. No clause should be considered in isolation. The whole thing should be looked at, and it should be looked at in context, because I think BELA is a test case being used by the state to see what will be tolerated by the citizens of South Africa. To date, the ANC and the EFF have both had no difficulty in shoving BELA through in spite of all opposition, with all parts of Clause 2 intact, and the degree of spin doctoring and leverage of propaganda has been amazing to watch, but most people have no idea what to even look for. So it's been very successful to complement the ruling party's flagrant disregard for ethical concerns. It remains to be seen whether they manage to shove it through again, in spite of the extensive public opposition voiced through written and oral submissions during the recent public hearings processes, and I hope to be able to comment on those processes in more detail soon. But in South Africa's current political climate, the commitment to human rights on which our Constitution is founded is one of the very few lifelines still available connecting us with the Freedom Charter and Madiba's original vision for the Rainbow Nation. So please, we've got to put human rights at the center, and we've got to start doing it now, and we've got to start doing it meticulously. Rejecting the BELA Bill outright might be our chance to unite in drawing the line and finally turning things around against corruption and decay. There's only one more public hearing on the 4th of April in only one province, and that province, the Western Cape, still remains open for you to have your say in other ways if you can't be there in person, because we can turn this around. We really can, but it's going to take concerted action. So what can you do? Firstly, you can reality check this presentation. If you think it constitutes misinformation, please go to the original sources linked within the slides, have a look for yourself. I'll post the links in the video description, and here's a nice summary of some of the key documents as well. If you feel like it doesn't constitute misinformation, then please share it to your contacts and your social media and make your own versions, take out bits from it, make your own posts. As I said, you can do what you like with this thing as long as your intent is pure. If it's not, please, whatever. We'll have to trust karma to get you. It won't be me, because I'm just not that person. You can write to the Western Cape Provincial Legislature before the 4th of April. There's the email address. I'll put it in the links. In the description. They've made it really easy in the Western Cape. I don't know why the rest of them couldn't do it. There's WhatsApp messages. There's even a form, an online submission form. But whatever you do, please realize if you're going to push back on the BELA, please be respectful, specific, and accurate so that your submission isn't discarded. You are writing to people who did not draft this bill but do have the power to change it. So engage with them in a positive way. Another thing you can do at a broader level is learn more about your own human rights and share that information with other people. There's an amazing amount of material online, and even some right here on the same channel that you'll probably be watching this. And then support young people in learning about their rights. Here's a place to start, Run for Kids by Kids, and you can check out Fardine's work, but also start having a look at empowering kids so they can have a lived experience of their own rights, because contrary to what people think, children with rights are actually better behaved than children whose rights are not acknowledged. This is part of a confusion that people have of the difference between entitlement and rights and license and rights, and this is again something I need to speak about on a different occasion. Thank you for taking the considerable time needed to watch all of this. I'm not going to be editing this video, otherwise it will be out too late. So it's going to be in with all its human frailties. Thank you for taking time to consider these points, even if they're uncomfortable or difficult to digest. I really welcome all comments that are respectful and thoughtful, whether you agree or disagree. The comments will be below this video and will be available, and we could have some useful conversations there. And finally, this is my sincere opinion. I don't have time to run it by any colleagues before getting it out there. Time is tight, and so it does not necessarily reflect the opinion of everyone associated with full human rights experience education, aka free. Thank you, and happy extended Human Rights Day in South Africa. May we reach a point where they have more of a place in our society, because that could be a beautiful future.